Okay, hi everyone. So welcome to the another session of Clat, and today's session, as it is named, it is last lap to Clat. Why last lap to Clat? Because we have very few days left in our hands, so we have to put the most of efforts, you can say the best of our efforts, because the countdown begins. And considering the countdown begins, it is also the time where you have to figure out a final strategy, or final, you have to give a touch to your exam, that okay, now I am ready to face the CLAT examination. I have practiced a lot, I have practiced mock, I have covered all current affairs, I have covered everything from legal perspective, the basic, the static portion. So when I say the static portion, okay, so before I get into the static portion, I would want to say that if you look at CLAT and if you look at legal section, as I have stated this earlier also, and I'm repeating this again, and I mean I have been repeating this, that CLAT focuses on two aspects. One is static, the second one is current affairs. So current affairs we have studied, static also we have studied. But when I interact with the student, I feel like somewhere you guys are still struggling with the basic concepts, or you guys don't understand the basic difference. For example, if I ask a question as to difference between indemnity and guarantee, so sometimes you get stuck. Similarly, if I ask the basic question as to what is the, so when we take into consideration voluntary non-fit injuria, sorry, there's a packet. So yeah, when we say voluntary non-fit injuria, so you guys know that VNFI is an exception to the general rule, but you guys don't know that rescue cases is also an exception to VNFI. So considering till the time our basics are not strong, we would not be able to ace the legal section. Why I focus or keep saying that our static should be strong, because even if there's something in news from current affairs perspective, they do ask the same in static format. For example, if we had Vizag gas leak, so they asked in the paper what is absolute liability, what is strict liability, what is polluter pays principle. Similarly, if you have fundamental rights in news, so they have asked questions from article 19, they have asked questions from article 20. So considering that, similarly, they have asked questions with respect to communication to contract. They have asked questions with respect to VNFI. So we need to understand that, or vicarious liability, that if our basic is strong, we are going to ace the paper for sure. Because even if something is in current of news, it has some weightage, or it has some importance from the static portion also, because you have a law, then only you are seeing it in news now. So considering that, I'm telling you guys to again go back and revise the static. If I'm saying static, so do revise tort. If I say tort, so what is tort, what is you can say the general exceptions under law of torts. Then you have to understand the basic concept also, when a person can be said to have committed a tortious act, when a person is said to have not committed the tortious act. So considering that, that should be on your tip. Then all the eight exceptions shall be on your tip. Then certain types of torts, like if we say negligence, nuisance, trespass, malicious prosecution, vicarious liability, we shall be familiar with these concepts. Similarly, if we move to contract, so in contract, we shall know the basics of contract. We shall know what are the five ingredients which makes a valid contract. We shall know that who all are not entitled to enter into a contract. What are the grounds on which a contract becomes void ab initio? What are the grounds on which a contract is void? What are the grounds on which a contract becomes voidable? Like we have to understand what is fraud, what is misrepresentation, what is undue influence, what is coercion, what is a mistake of law and mistake of fact. Mistake of fact, that mistake of fact can be with respect to subject matter, it can be with respect to substance, it can be with respect to parties. So agar what is contingency contract, what is wagering agreement, what is contract of indemnity, what is contract of guarantee. So from contract perspective, this you shall be know. Similarly, if we move to constitution, so our basics with respect to schedule, our basics with respect to fundamental right, Article 32, Article 226, Article related to Supreme Court, Article related to constitutional bodies, Article related to government. So all these we shall be familiar with. Similarly, certain TPSP, like if I say Article 50, which talks about separation of power, legislature shall not enter into, or executive shall not enter into the domain of judiciary. Similarly, judiciary shall not do the so, vice versa. So considering that all these things we need to know from constitutional perspective, and especially focus shall be on Article 14, Article 19, Article 20, Article 21. Certain schedule are in use. For example, Article Schedule 5 is in use, Schedule 6 is in use, Schedule 9 is in use, Schedule 10 is in use. So considering that we shall be very much familiar with these schedule. Also Article 12, because Article 12 defines state, so we shall be knowing what is state. Similarly, there are many issues from current affairs perspective which has something to do with constitution, because constitution is the grand norm of the country. It is the highest law of your country. So any law which violates the provision of constitution, to the extent they are violating the provision of constitution, will be declared as ultra virus. So considering that we shall be familiar of these concepts from constitution. Similarly, if we say criminal law, so criminal law, again here I'm not asking you to go back and revise the sections given in IPC, or revise a section which is given in BNS, or what changes, or what are the sections talking about culpable homicide or abatement. No, you need to remember the basic concepts, like what is actus reus, what is mens rea, what is common intention, what is similar intention, what is culpable homicide, what is murder, what is theft, what is abatement to crime, what new additions has been done, what is community services, what is mob lynching, what is terrorism. All these things has been added. What is organized crime, pretty organized crime. So these are few things which you need to remember from the criminal law perspective. Similarly, the basics of family law, like marriage, Hindu marriage, if I say, so you shall be aware of what the section 7 says, because at many occasions Supreme Court has highlighted the same. Similarly, certain concept as to divorce and all, whatever is in use from family law perspective, you shall be aware from the static aspect. So these are few things which you need to right now revise from the static portion. Other than these static aspect, obviously you need to go back and revise the current affairs also, because questions can be asked from the current affairs also. Now if I take into consideration last session of mine, so last session I was supposed to discuss these topic, but because of the time constraint and we were discussing the strategy and all, I couldn't cover these topics. So I had stated that I'll be covering this in next class. So when I say the first topic, which is right to disconnect, so right to disconnect has been very much in use from the perspective of, you can say, mental pressure, or mental, you can say, the pressure, not able to handle the pressure which is there with certain people. And also how does it impact a person's health, mental ability, how does this impact the person's overall well-being, is something which is considered as a, which is the concern of right time, we can say. And we have seen recently there are certain death which has highlighted the health issues of the employees. For example, we must have seen in news there was a death of a person who was associated with a company, where it was said that she allegedly died due to overwhelming work stress. The right to disconnect is in discussion from this perspective only. So there was a recent survey which was conducted by Indeed, which is the global job matching and hiring platform, which revealed that 79% of Indian employers believe that implementing a right to disconnect policy at work would be a positive step forward. So, what is right to disconnect? It refers to an employee's right to disengage from work related communications such as emails, calls, or messages during non working hours. And this basically ensures that employees are not obliged to be available outside of their contractual work hours, promoting a balance between your personal and professional life, which we also call as a work life balance. And with the rise of digital technology, and you can say the proliferation of smartphones in market, employees are increasingly expected to remain connected to work even outside their formal hours. And this also leads to digital, you can say, kind of focus on more on digital aspect, where employee feels compelled to respond to work communication at all the time. Need Why there's a need to have a right to disconnect, because mental health is very important. Second is work life balance should be there. Third is, if you want to have a more productivity in organization, so you need to give break to the people also, no? So that they can, tomorrow if they are coming to work, they are coming up with a very fresh mind. Then it also is kind of protection against exploitation. It also works on the physical health of a person, because mental health, physical health, both goes simultaneously and both needs to be focused on. And if we talk about the global data with respect to right to disconnect, so France was the first country to enact the right to disconnect. Australia in 2024 also passed the legislation which ensure that employees are not penalized for not being able or available outside the working hour. Germany is also having similar law. There is no per se law in Germany, but several companies have voluntarily adopted internal policies to limit after hours emails and communication. India right to disconnect is not legally recognized. Member of Parliament has drafted a, like Supriya Sule has drafted a private member bill for such a right through the right to disconnect bill of 2018, which was never taken up for discussion in the House. So, considering the current scenario, this is again very much in news, and we need to focus on the same. So, this is with respect to right to disconnect. So, you also need to remember that we had discussed right to be forgotten also, which sometimes you see in news is relevant from our exam perspective. Now, coming back to why I'm referring to these information is not only relevant from your legal section also, but maybe relevant from, because mental health and everything is there. We have Mental Health Care Act also. So considering this can be asked in legal section, and this can be asked in your GK section also. Then the second topic is with respect to new flag and insignia of Supreme Court. So the Indian president has unveiled the new flag of the Supreme Court. So if we are talking about the same, so we can say that the new Supreme Court flag is of blue in color, since Supreme Court is celebrating 75 years of its establishment. So it is very important from our examination perspective. The flag prominently features the symbol central to Indian legal and cultural heritage, that is a Asok Chakra, or you can call it as the Dharm Chakra or the wheel of the law. Uh, and then you can say the Supreme Court building also is at the center, and the Constitution of India is below. So Ashok Chakra is at top, Supreme Court building is at between, and the Constitution of India is below. Then it is also inscribed on its Supreme Court of India, and there's a sloka also which is saying Yato Dharmasto Jaya, which basically means where there is a dharma, there is a victory. Or you can also say victory lies where dharma is being prevailing. Or here, when we talk about dharma, we are basically talking about the right things. And then symbol of Asok Chakra is inspired from, we all know, Sarnath land capital, which was created by the third century Mauryan Empire, Emperor Ashoka. You can say the new flag and everything has been designed by National Institute of Fashion Technology, Delhi, NIF Delhi. And if we talk about the Supreme Court, so we also need to remember the key aspect of Supreme Court. So it is the highest judicial body in the country, serves as the final court of appeal, as well as the ultimate interpreter of the Constitution, and established under Article 124 of the Constitution. It came into existence on 26 January 1950 by replacing the Federal Court of India. And with the coming into force of Indian Constitution, Supreme Court also came into picture. It plays a central role in, upholding the justice, protecting the fundamental right and everything. So there are certain constitutional positions and powers which is there under Supreme Court articles, like Article 144 to 147 includes the original jurisdiction aspect, appellate jurisdiction aspect, advisory jurisdiction aspect. Then we also see the concept of judicial review. I mean, judiciary has a part to review the laws made by the parliament, so that the parliament does not make an arbitrary law. Then when we talk about what are the significance of Supreme Court, so it is the guardian of Constitution, you can say. It is the protector of Constitution, you can say. It protects your fundamental right. It takes into consideration the public interest litigation. It is also ensuring the federal balance is being maintained in our country. Then judicial activism also, you must have heard at multiple times that court is very proactive in, addressing the social issues and upholding the right through its judicial activism. Like right now you are seeing too much of debates happening with respect to women's protection, and at workplace also Aprajta bill has been introduced by Bengal government also. So Vishaka guideline, which is talking about the protection of women at the workplace, or you can say, or prevention of sexual harassment at workplace, is also a kind of a result of, you can say, judicial activism. Then development of constitutional law. So we can say the Supreme Court is central organ in our country, or the main organ in our country, from the purview of maintaining democratic values, protecting rights, ensuring rule of law, and keeping an eye on the government also with respect to creating a check and balance on the working of the government, so that your fundamental right at no place is being violated. So considering that, it is very important. Now, moving ahead with respect to new draft guidelines on passive euthanasia and Supreme Court strengthening law against child pornography in India. So we have seen a recent case also where Supreme Court discussed about the, saying where in a phone a video was found with respect to child pornography, and the court stated that you are liable under POXO Act and you can't take the defense of saying that ignorance of law is not an excuse. So when we talk about, first let's cover the passive euthanasia thing. So when we talk about euthanasia, we all know there are two type of euthanasia, active and passive. Here in India, we are having passive euthanasia and not active euthanasia. In case of active euthanasia, there is a deliberate act. So basically, there's an administration of some drug, lethal drug, to end an incurable patient or the patient who is in a vegetative state, and there it is being taken into consideration. Active euthanasia in India is a crime. Only those who are in a vegetative state can be taken off life support with the help of the family members. Passive euthanasia is basically what it is known as, refers to intentional withholding or withdrawal of medical treatment or life support sustaining interventions, like you can say, what we call it, as a person is being given certain life support, like आप उनको किसी मास्क वास्क ऑक्सीजन मास्क पे continuously survive करा रहे हो, या life support system, anything can fall within that category. So it basically includes, or what we call it as a ventilator, the term was not coming. So includes stopping treatment like ventilator services, feeding tubes, medication that keeps the patient alive. So there are two cases related to this. One is Arna Schanberg, and the second one is Common Cause case versus Union of India, where Supreme Court recognized a person's right to die with dignity as a fundamental right in aspect of Article 21 also, but only in case of passive euthanasia, where the patient is terminally ill. It can opt for passive euthanasia, execute a living will to refuse medical treatment if they slip into incurable coma. So the draft guidelines for passive euthanasia is for defining what is terminal illness, which is saying that it's an incurable condition from which death is inevitable in the foreseeable future, and it is based on four conditions only. The individual has been declared brain dead, brain stem dead, you can say. There's a medical assessment that the patient condition is advanced and unlikely to improve with the aggressive treatment also. The patient or their struggle has provided informed refusal to continue life support after understanding the disease and everything, and the procedure follows the directive which has been set up by the Supreme Court. So this is with respect to euthanasia, and recently we have seen certain judgments also focusing on euthanasia's perspective. So considering that it is relevant from our examination perspective, and since it is covering Article 21 also, so considering that wherever fundamental right 14, 19, 21 is in news, it is relevant from our examination perspective. And the last one is Supreme Court strengthening law against child pornography in India. So there is a, you can call it as a significant move in fighting against child exploitation. The Supreme Court of India has emphasized that the consumption of sexually explicit content involving minor is a severe criminal offense under POXO Act. And court stated, basically court overruled a judgment which was given by Madras High Court, which held that the passive consumption of child pornography did not constitute an offense under POXO Act and Information Technology Act. So the Supreme Court has expanded the interpretation of Section 15 of the POXO Act, and it says basically it punishes any person who stores, possesses pornographic material in any form involving a child with the intention to share or transmit child pornography for commercial purpose, with a 3 to 5 year jail sentence. And this is something which also falls within your syllabus. There's a heading called moral philosophical aspect. So considering that this POXO Act from legal perspective, from public policy perspective, and from the moral philosophical aspect also, it is very relevant. So Supreme Court stated that Section 15 is not limited to punishing the sharing or transmitting of child pornography material, but it can even be used to punish the intent to commit such an act. For instance, the court held that failure to delete or destroy or report child pornography would allow the court to indirectly infer that the concerned individual intended to share or distribute it under Section 15. And they also expanded the definition of possession in child pornography. They said that where an individual may not have physical possession of child pornographic material, but they have the power to control the material in question and knowledge of exercise of such control, then they will also fall within the purview of Section 15. And the court termed the constructive possession and held that viewing, distributing, or displaying such material would still constitute or would still amount to being in the accused possession under Section 15. And courts also stated that you cannot take the defense of ignorance of law, that I wasn't aware of any such law. And then Supreme Court has also recommended to the center to address the issue of child pornography. So basically, to remove the term, replace the term child pornography with sexual exploitative and abuse material to better reflect the nature of crime. Court has also asked the government to help victims to heal and regenerate into the society. Court has also asked to introduce cognitive behavioral therapy program to help address the distortion that fuels such behavior amongst offenders. It also has asked to promote coordinated effort like educators, healthcare providers, law enforcement, child welfare services to identify individuals with problematic sexual behavior earlier and implement intervention strategies. Court has also asked to raise public awareness. Public campaigns should aim to uh, inform people and also to report and encourage vigilance within the community, and formation of an expert committee to devise comprehensive program for health and sex education and increase awareness of POXO among children from a very early age. So these are some of the things from the current affairs perspective which I wanted to discuss in the today's class. In upcoming videos, like in upcoming sessions, like today we have summed up the current affairs from 1 month. Similarly, we would be summing up current affairs from the other months also, and Supreme Court judgment, which is relevant from the examination perspective. So today's session is all about this only, guys. See you in the next video. And you can also come up with suggestions, like if you are struggling in any of the static portion and you want me to cover that, please do let me know. I'll be covering the same in the next video. First, I'll cover your static portion where you are struggling, then we'll move to current affairs. So thank you so much, guys. See you in the next video. Thank you.